Okay. This is some fragginackle bullshit. Okay, this is what it is. Actually, this is not so bad. Alright, here's what I'm gonna try to do, because I want to be able to follow the chat. I'm gonna wait and get some people back here before I start. Hopefully you all can see me and hear me. Y'all will let me know. Let me know. Let me know. Okay, family, I see y'all all there, and so I have it on. This is better. It's not better technically, but it's better in terms of, us trying to move forward. Now I just need to turn off these comments on this phone. That way I won't be distracted. So I have the comments on. I can see, you can see and hear me. Yes, thank you, Raven. Hello, Hot Block Commander. All right, I think we back in action. Let me do a couple things, like do not disturb because I'm on my phone. And all right, I think we cooking with gas. Good. All right. All right. Thank you. Thank you. All right. Let's give some people some time to get back in here. I'm using the phone, and the desktop did me filthy. So if you don't know, YouTube is changing their live platform, and so they have oftentimes they have beta things, and they just have something where you have to go through a streaming service, and I ain't got it. Your skin, thank you. My skin, I gotta shout out my girl Courtney at Massage Envy, who is my esthetician. She's amazing, and she takes very good care. I take good care of my skin too, but she does as well. So shout out Massage Envy, and thank you. Peace Queen, will you address what Judge Joe Brown had to say about the Byron Allen case? Divine, you got to tell me what Judge Joe Brown said. And that's funny. I've had exchanges with him on not Instagram, on Twitter, back and forth. He DM'd me actually. It was weird. I was like, this is weird. But we had a good exchange, and I haven't seen what he said recently. So you guys tell me what he said, but tell me in a few minutes so I could get out some of what this is all about so because everybody is not following, and so let's just catch everybody up. Okay. Byron Allen has a media company. He has a number of channels and whatnot, and he had been trying to negotiate contracts with Comcast. I would say the briefs that I've read say for the past 6 or 7 years. 6 or 7 years, he had been trying to get Comcast to contract with him to carry his channels, which are all African American channels. He has an African American media company. Okay, so after 6 or 7 years of trying to get them the contract, he's like, okay, this is some bullshit, and he decides to file suit. So he brought suit in federal court under the Civil Rights Act of. This is a misnomer. It's not really under the Civil Rights Act of 1866, but it's under 42 USC 1981, which is the codified statute of that act. I'm going to say that again. Okay. Civil Rights Act of 1866 was codified. Okay, so it's in the United States Code. When I say USC, that's what I'm talking about. That is the bulk of federal statutes that are broken down by title, right? And so 42 USC 19, I don't know why my hands is over here. 42 USC 1981 codifies, and it almost mirrors the language verbatim. And I have the language right here. I printed it. And it almost mirrors the language verbatim of the Civil Rights Act. So Section 1981, this is what it says. It's one of the oldest civil rights laws, and it provides the following. It's a statement of equal rights. It says all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, right? This is what's important. because this statute is not an employment statute, and I'm going to tell you why that's important later. All right. It says, all persons within jurisdiction of the United States have the same rights and territory, making it force contracts to sue, be third parties, give evidence, and to full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by white citizens, and shall be subject to like punishment, pains, penalties, taxes, licensing, and exactions of every kind, and to no other. Okay, so that's 1981. 1981 says that black people have the right to contract the same as white people. Now, there was some cases that came down the Supreme Court in 1989 or thereabout, which brought about congressional action to speak to those cases which narrowly defined the Civil Rights Act. Congress said, hey, that's not what we meant, right? Let's be clear. So Congress enacted the Civil Rights Act of 1991. Stay with me, 81, 91, I know. But 1991 only was enacted to clarify and broaden the 1981, right? Section 1981, right? And so what 1991 did was say, we're not just talking about your right to contract. We're talking about everything. Your right to terminate a contract, your right to negotiate a contract, everything that has to do with that, right? So they made sure that it was understood that this section should be read rather broadly. That was the congressional intent of the time. So what is the argument? Oh, not even before we go to the argument. Let me go and tell you how the case proceeded. So Byron Allen bought this suit and said, hey, these guys are not contracting with me because I'm black, right? They are not contracting. And in his pleadings, and that is the complaint that was drafted for the lawsuit, you have to allege specific facts, right? And so that's this terminology called stating a prima facie case. A prima facie case just simply means that you have alleged the bare elements required to establish your case. You just have the bare elements, right? You've laid out facts that support the bare elements of this case. So typically what happens when there is a lawsuit filed, the first thing that the defendant does, right? A plaintiff is the person who brings the suit. The defendant is the person who defends against the suit. And this is a civil case, so there's still a defendant. And so the defendant moved pursuant to Federal Rule 12b-6, right? Make sure I get it right. Could be 12b-6, which is a summary judgment motion, right? So we're gonna get a lot of legal questions, a lot of law tonight. Summary judgment. Summary judgment is a motion to dismiss. What you're saying in a summary judgment motion is you're saying to the court, hey, there are no facts here that a jury would have to decide. There are no facts, and in fact, there's only one legal issue that you can decide, and the legal issue militates in my favor, and such that this case should be dismissed, right? Summary judgment says you don't have any facts that can state, there are no facts in dispute for which we need a jury. We only have facts, we only have in dispute what the law is. And we say the law is on our side. So they filed their motion for summary judgment, and in the district court said, you're right. They haven't. This is not a sufficient pleading. It's not enough. And they dismissed Byron Allen's case. Well, that wasn't the end of it. Byron Allen said, okay, well, you know what? We see it a little bit different, and we have some precedent, right? We have some prior cases that we think are on our side. So they filed an appeal. They appealed to the Ninth Circuit Court of Appeals. Okay, that's the intermediate appellate court on the federal level, right? You have your district courts, you have the Court of Appeals, and then you have the Supreme Court. So they filed an appeal to the Ninth Circuit. The Ninth Circuit said, oh, the lower court, you got that wrong. You got it wrong. And you got it wrong because it's okay for him to plead that the reason you didn't contract with me was because I was black, right? The question turns on is, whether or not I have to establish that that's the only reason that you contracted with me, or is it enough for me to show that it's just a reason? All right, y'all following me so far? The lawsuit will not affect us either way the court rules. That's not true, Divine. That's not true. It actually could have. It could have. It could have enormous impact. It could have enormous impact. And I'm going to tell you why. Judge Joe pushing his show coming up. The case been going on 4 years. We decided to put Allen on blast. I got to figure out about the Judge Joe. I just want to make sure everybody is with me up until this point so far. All right. We up until the point where they're in the Ninth Circuit. The Ninth Circuit reverses the lower court and says, Byron Allen, your case is not dismissed and you can move forward to trial. Right? Comcast, unhappy with the Ninth Circuit decision, filed for writ of certiorari. Writ of certiorari is a request to the Supreme Court to hear a case. Excuse me. The Supreme Court granted the writ of certiorari, which just means that they have agreed to hear the case, which they did. They heard oral arguments last week, and so at some point we're going to have a decision. The case just turns on this proposition of whether or not a plaintiff who is pleading intentional discrimination, which is not to be confused with disparate impact discrimination, which is different. That's unintentional discrimination, and I'll explain that in a second. But when you're pleading intentional discrimination, is it sufficient for me to plead that race was a motivating factor? Byron Allen says, the law says it's enough for me to say it was a motivating factor. Comcast says, no, the law requires it is the motivating factor. And that is what the dispute is about. Whether we are going to apply what is called the but-for standard in these civil rights cases. What is all of the confusion? Here's where the confusion lies. We have some other civil rights acts and cases and statutes, right? We have the Civil Rights Act of 1964, and we have Title VII pursuant to that, and we have the acts against discrimination against age. That's for Americans who are 40 and over, age discrimination, which is prohibited in employment. And so what Comcast has said is listen, when you look at the Civil Rights Act of 64 and Title VII cases and age discrimination cases, you're not allowed to plead a but-for causation. Right? There is under Title VII, it doesn't permit you to sue under what's called mixed motives, right? Mixed motives, meaning that it could be discrimination and something else, right? It's more than just discrimination. And so Byron Allen is like, I should be able to plead mixed motive. I should be able to plead that it is a factor, one factor at least. Now, I'm gonna say one more thing, then I'm gonna text comments. When a plaintiff sues and alleges discrimination, there's a lot of back and forth when it comes to the burden of proof. A plaintiff must allege facts to establish discrimination. The employer must then come forward with facts that says, I didn't fire you because you were black, or I didn't contract with you because you were black. I was not going to contract with you anyway, right? For what other reasons? And they have to come up with other reasons. These other reasons, of course, have to be or we call neutral, race-neutral reasons, right? Then once they come forward with their race-neutral reasons as to why we won't contract with you, it shifts back to Byron Allen to say, those reasons you gave are pretextual. Pretextual is code for bullshit, right? Pretextual meaning that you made those up. And in fact, I can dispute them. So what did Comcast say? Comcast said, We're not contracting. It doesn't have anything to do with his race. We can't carry those channels. We don't have the bandwidth, right? That was their race neutral argument. We just can't do it. It's impossible, right? They can't. He's got all these channels. We can't carry them. We cannot accommodate them. Byron Allen came back and said, "Really, you can't accommodate me? That's some bullshit. You told me I was on the short list so that you would eventually contract with me at some point. Not only that, in the interim, when you were saying you didn't have the bandwidth or you couldn't take my channels, you contracted with 80 other white-owned channel owners or networks or whatever may have you. 80, all white-owned. You had the bandwidth for them." So Byron's, his argument is that your race neutral reasoning is pretextual. You just making that shit up, right? Now, under the standard that Comcast wants to use, the but-for causation, they would win. They would win, right? Because you have to prove it's the factor, the only factor, not a factor. Right? And that has this that would have a trickle down effect for any future contract discrimination cases under this title. Right? So because so far under 1981, the court has not held that the default standard but for that is used in 1964 cases and in Title VII cases and in age discrimination cases is the same default that should be used for the 1981 cases. And the reason they say that it should be different is because those cases deal with employment discrimination and these cases deal with contract discrimination. All right, completely different. And being that the Civil Rights Act was done specifically with the intent to fix wrongs and specifically to speak to cases like Dred Scott and things of that nature, the argument is always that Congress's intent is to make sure that you have the ability to contract in places where you traditionally were locked out of. Okay, now I could take a break. Why would you want to be a Democrat? What y'all talking about in this chat? Wait, hold on. I'm supposed to make Rodney a moderator again. Fuck you mods. Why are you cursing, Chief W? Bell Atlantic Corp. 2007 made it clear that a complaint must allege sufficient facts that, if accepted as true, state a claim for relief plausible on its face. Yes, that is what is called a prima facie case. If you read in the chat, please go back into your history, interview all exes, ensure they're sane and not harder for money. Byron, you think they're gonna come for Byron Allen next? Well, here's one of the things that he pleaded in his papers was that someone from Comcast, one of the executives, was of the mind or of the opinion that they did not want to contract with Byron Allen because they were not going to make him another Bob Johnson. Yeah. We're not creating another Bob Johnson. We already had one of them. We're not about to contract you and let you get bigger than you already are. Right? What's really at stake here is Byron Allen is not successful. What's really at stake here is the court applying a standard to this statute that would make it almost impossible to prove intentional discrimination. That's what's at stake. If the standard is changed from 1981 cases and proving intentional discrimination, it will be almost impossible to prove that race is the only factor. That's almost impossible to prove, right? And so the argument is it should be looked at as you should be able to plead that race is a motivating factor. If race is a motivating factor, is that not something that we want to legislate against? Isn't that the point of these statutes? Is to keep people from engaging in discrimination based on race? I mean, I think that's the case. Nothing to do with black people. It does have to do with black people. It may not have to do with black people who are committing crimes or standing on corners because they are not looking to contract with white people. But those black people who do have businesses who inevitably cannot not contract with white people should be able to do so without the fear that if they feel that they have been intentionally discriminated against, that they have no recourse. Right? And so it is important in that regard because so much of what we do is contractual. So much. And if you can't bring your case because the standard is just simply too high, you can't even make out a prima facie case. As soon as you get into the district court, your case is going to be dismissed on a 12B summary judgment motion. Oh, okay. I'm trying to go up, not to import conjecture, but after the chain of events that occurred when Cosby reportedly tried to buy a network, does Allen probably is worried about that, I'm sure. Oh, you finally on. Okay, Rod, I see you. Let me, I think you're still a moderator. I'm sure, look, Byron Allen is not stupid. I know that he knows that he's on the radar. I'm sure 100%. And so I'm sure he is governing himself accordingly as a result of that. I still don't know what Judge Joe Brown said. I want to know who is the other party to this lawsuit with Allen. Who is the National Association of African American Owned Media? That's who the other party is. The National. Google them. And how come none of the member companies or owners are being mentioned? I don't know. I can't answer that for you. I don't know. It could be that Byron Allen he's the most recognizable face when you're trying to bring attention to a cause and a case. You want to put the people out there who are the most recognizable, who people are going to listen to the most, and so that could be the case. I can't say who the other people are. Okay. All right. Let me just look at my notes and see what else I wanted to tell you guys. Just for your edification, I was talking about how Congress responded to a couple of the Supreme Court cases that happened around 89, 90, and as a result of Congress's interpretation of this act and narrowing the act, the Supreme Court's interpretation and narrowing the act, Congress decided to respond with the Civil Rights Act of 1991. And particularly, it spans the make and enforce contracts that I read to you from the 1981 statute. It expands that to include termination of contracts and the enjoyment of all benefits, privileges, terms, and conditions of the contractual relationship. Because the Supreme Court interpreted that said only make and enforce. That means that it has anything. You don't have the right to terminate a contract. You don't have a right to negotiate a contract because statutory interpretation is very strict. It's very strict. If you intended it to mean something other than what it says in its plain language, then you have to legislate for that. Okay, I don't know who's quoting this guy. I'm not even going to say him on my damn live. But I won't be quoting him. 2.5 hour interview. There are a number of interviews with Byron Allen. He did one, I think, 3 hours with Karen Hunter on Sirius XM Urban channel, Urban 126 Urban channel. It's on, and it's on demand. If you have Sirius, you can go on, you can watch it. He has, I think he did an interview with the Breakfast Club. And he's done a couple of them, and I mean he's trying to get the word out so people are aware of what's going on. And think about, I mean, you think that this is not important. If it wasn't important, why do you think the Department of Justice, Trump's Department of Justice, filed an amicus brief on behalf of Comcast? That's important. Why do you think they're getting involved? That this is not a big deal. It's a big deal. Okay, this is predominantly white country. Yes, it is. So you can't, I mean, I know Killer Mike had that, he had that what was that show on? Killer Mike had the show where he spent one episode and he said he wasn't going to deal with white people. He wouldn't contract with them. He wouldn't spend any money with them. He wouldn't support them in any way. Remember how difficult that was? He couldn't go to a hotel. He had to sleep outside on a damn bench, right? Because there was no black-owned hotels where he was. Remember, I don't know if you guys saw this. I thought it was hysterical. He couldn't go buy weed. He literally was looking for black marijuana growers, right? Because he's like, I can't buy weed because it ain't black owned. It wasn't grown by black people. It hasn't been harvested by black people. So he couldn't buy weed. And so the reality of it is it's very difficult to try to do business in this country without contracting with white people. And I don't see why he would want to. Like, I mean, for the benefit of us as a whole, I'm going to contract with whoever I have to make sure we have and need what we have as a people. I'm not. I'm not sleeping on nobody's benches. People saying he's running game on the people just to support for his case, and this is not about civil rights. No, I disagree. I don't know how does he have the power to run game such that he could bring a case that ends up in the Supreme Court? He didn't file for the writ to get to the Supreme Court. Comcast filed for a writ. In fact, his lawyers argued against the writ. His lawyers argued that the Supreme Court had no right to grant a writ to review a dismissal of a summary judgment motion. Right? So it's not his fault that this case is in the Supreme Court. This is where it is. And as a result of that, he just wants to bring attention to it. I can't be mad at him about that. And I haven't seen anything to make me question, his intentions or his motives. I just haven't seen it. He did I'm sorry, the 2.5 interview I was speaking about is with Judge Joe Brown. Okay, did he do an interview with Judge Joe Brown? And then Judge Joe Brown came out after and said something untoward about it? I don't know. I'm not in the loop on this one, family. I apologize for that. Even if hold on. Because they are still ruling. Yeah, they are ruling for, they're still the majority, not global majority, but the United States majority. What is Byron's proof that Comcast is discriminating against him? Probably, that's a great question. So what Byron Allen has indicated is that numerous meetings. At one point, Comcast sent him to meet with other divisions of Comcast under the pretense that he was going to have his channels picked up. He spent an inordinate amount of money in marketing and promotions and everything, thinking that they were going to honor the negotiations, only to have them fall through. And then when you can establish that what you've been asking for you weren't given but was then given to someone of a different race, that's your prima facie case. That's your prima facie case right there. And it's not just one other company. Comcast contracted with 80 other companies. 80. And they all just happen to be all white owned? That's interesting. That's interesting. And so that's part of it. And remember, we're at the pleading stage. So he doesn't have to prove, he doesn't have the burden of proof that he would at trial, right? Stating a prima facie case is not proving your case by preponderance of the evidence. That's what he has to establish at trial. But to get to trial, he has to survive the summary judgment motion. And that's what this is about. It's about that summary judgment motion. And the Ninth Circuit reinstated his complaint and said, you have a case. It is okay if you plead in this mixed motivation type of discrimination, you can plead that race was a motivating factor. And now the Supreme Court has to decide whether or not the but-for standard is applicable here, or if the standard that a motivating factor is the proper standard. And that's gonna make a big difference in how these cases wind up through the court. I don't want to fight to be a partner with racist white corporations to carry black. I don't want to fight either, but information is power. Let me just say this. Information is power. And right now, there's a handful of companies and corporations that control all of the information. All of the information, how it's disseminated, who is disseminated to, when it's disseminated. They control all of that. And so I think it's incumbent upon us as black people to get a hand on that. Somehow to get a hand in that. So that we could have some narrative too. And so if Byron Allen can get to the point where he can have a news channel or something to that effect, then I support that. I support that. CBS wants on Comcast, but they signed a contract with Fox. That's why they're using Allen to get what they want. Okay. So why is the Supreme Court involved here? Seems like the but-for test and discrimination law would have been addressed by now. It has been addressed in many, many instances, except for when it comes to cases that involve intentional discrimination in contracts under 1981. Remember, you have to remember there's more than one type of discrimination. There's a lot of different types, right? Typically, you've heard of hostile work environment discrimination. There are different standards to prove different types of discrimination. There's another one, the disparate treatment, the disparate impact. Those are two different types, and they're actually the opposite. So Byron Allen is arguing disparate treatment. When I say disparate, I'm not saying desperate. I'm saying disparate, D-I-S, disparate, D-I-S-P-A-R-A-T-E, disparate treatment, right? He's arguing that is intentional discrimination. However, under certain other sections of certain other civil rights laws, you can argue disparate impact. Disparate impact is unintentional discrimination that has a disproportionate effect on a protected class. Let me say that again, because sometimes I feel like there'd be a lot of shit in my mouth. Okay. Disparate impact is unintentional discrimination. That means there's not an intentional policy on its face, or there's not someone doing something on its face to discriminate against you. But whatever they are doing is having a disproportionate effect on a protected class. Let me give you an example. Say, for instance, there was a factory. I think I used this in school. I'm trying to find the best one. Say, for instance, there's a factory, and in that factory, they have a policy that you have to wear a hairnet, right? This is probably going to be a terrible analogy, but I don't give a shit. I want to get to my point. You have to wear a hairnet, right? And so when you think about hairnets, you're thinking right away, this will probably affect women more than it will men, right? Women tend to have more hair. Women tend to, will be affected more if they have to cover their hair. So this policy is going to disproportionately affect a protected class, right? Even though they didn't set out to say, we're going to come up with a policy that's going to discriminate against women, right? Okay. The other side of this is that sometimes it's okay to discriminate. If an employer can establish what's called a BFOQ, which is a bona fide qualification for the job that you don't have, then they can discriminate. Let me give you an example. Let's say, for instance, you are a Muslim. You wear a hijab, and you want to apply for a job teaching religion at the Catholic school. Y'all with me? So the Muslim woman wants to apply for a job at the Catholic school teaching religion. The Catholic school says, but you Muslim. And she goes, so I could teach Catholicism. And the Catholic school says, no, thank you. We will not hire you because we want a Catholic to teach Catholicism. More likely than not, that decision, even though based on protected status, religion, that decision will probably be okay, because the Catholic school can probably establish that there's a BFOQ, there's a bona fide a qualification here, occupational qualification. And in order for that job to be done properly, it needs to be filled by someone who has the faith, all right, who is of the faith, who can teach the faith, right? And it doesn't mean she can't teach, but they have the right to say this is who we want to teach. And so they will probably likely be okay with that type of discrimination. I don't think Comcast has that ability to say, well, we discriminated because those black channels, I can't even imagine what they could possibly come up with that would establish that they could use some type of BFOQ defense. Does Comcast carry Bounce, Afro TV? I don't know. How does this affect the case? I don't know if Comcast carry. I don't know what all the channels that Comcast carries. I'm sorry, I wasn't trying to find that. Yes, Jigga, Bounce TV, Revolt, TV One, Afrotainment. Nothing for need to return to fast food spots. Okay, wait. I'm sorry, trying to catch up on the comments. Not ABC, Disney, one of the big 6 media corporations that own 90% of the media. BFOQ, some unnecessary. Doctors need to be qualified to perform surgery. Exactly. Which is why the law allows for you to be selective enough when the position you're hiring for requires a certain type of skill and or training. But even in that, you still can't discriminate solely on the basis of races. You have to have a bona fide reason, a bona fide occupational qualification that this person just doesn't meet. Okay? Or you have to establish, like Comcast said, we didn't have anything to do with race, right? Our race neutral reason for why we didn't contract with them was simply because we don't have the bandwidth. We don't have the ability to carry the channels that they would like to carry, which is bullshit, because you were talking to them for 6-7 years, and in the interim you got 80 other channels. So I don't know. They say they black owned. I don't know. I have no idea. I have no idea. All right. So I don't know. If you guys have questions, I'll try to answer them in the comments. If you want to read any of the briefs on your own, you can just go to the Supreme Court website. Just Google Supreme Court. It'll come up. If you want to read what's on the blog, Google SCOTUS blog, SCOTUS blog, and you'll be able to see that as well. I hope I answered all of the questions and concerns and try to explain this a little bit. I know it's a little thick on the legalese, but really it's just about whether or not it's a motivating factor versus the motivating factor. If you take nothing away from it, then understand that. But for cause says it's the motivating factor, right? And the standard that it's not but for is just a motivating factor. Right, so if you take nothing away from it, understand that. Could they execute black codes that will affect the proceeding? I don't know what that means. Byron Allen should finance tech trade schools and give a low admission fee, no student loan BS. I'm not in the business of telling people what they should do with their money. But you could start something, Righteous 01. Right? I'm not about to be telling people what to do with their money. Not even Byron Allen. I can't. Apparently he's doing something right because he got a whole lot of it. So yeah, no, I'm not here to tell Byron Allen what to do with his money, honey. Is it difficult as a billionaire to create your own broadcast system? Apparently so. Apparently so. I mean, look at the people who have been trying to do it. I mean, I think Oprah tried, and she wasn't successful. They're like, here, bitch, take this channel. You better take this channel and keep it pushing, right? I mean, I think she's got a network, right? Her own network. But I don't think she has her own broadcast corporation, did you say? Something like that. I think Tyler Perry may have been trying to do that as well. We all know Bill Cosby was trying to do it. And now Byron Allen is also trying to do it. Shouldn't they sue under 1883 law? I don't know what law that is. 1883, don't know. He's not a billionaire. Okay. But does that seem like a deliberate block? If so, is that legal? I don't understand the question, man. I want to hear the black people who will benefit from Byron Allen wins this case. Yeah, well, it's kind of hard to hear from people who haven't, they haven't, their case isn't ripe, right? And so you're not going to hear from someone unless they have been discriminated in some kind of way dealing in a contract, right? That's so I don't I'm not sure what your expectation is. But I think I've covered it all. I've covered what I can. I know somebody not say Irv Gotti and the others when they report try to create district. Yeah, well, you see what happened with them. Listen, I'm telling you, if information wasn't important, they would not try to control it. They wouldn't be trying so desperately to control it, right? And so that's really what this comes down to, right? Is who is in control, who is in power of the programming, right? That's the word I have to use. There's no better word than that. Who is in control of the programming? Because that speaks volumes. That speaks volumes when you think about it, because programming is just that. It's programming. It's conditioning, right? It's all of those things. And so if we don't have a stake in it anywhere, and we don't have the protections in place to ensure that we can get a stake, then we don't have any control of what's being fed to not just us, but to our children. And that's scary. That's scary because not everybody is intellectually curious. Not everybody is going to go out and get the information for themselves, right? So many of us are content at being fed. You don't even check to see if what you're being fed is accurate. And a lot of what you're being fed is not the proper food for thought, right? That just makes me think of the 136 because the devil taught us to eat the wrong foods, right? The devil taught us to eat the wrong foods. That's not a literal lesson, right? Eating the wrong foods is talking about consumption, and what is fit for consumption, whether that is you physically eating something or you ingesting information, right? And so that's important. It's important that we understand that. All right. I think, Ikie, do you feel Comcast has attempted to pervert the law? Yes, I do. I absolutely do. I think that they are. I think they're trying to do some Jedi mind trick shit. I think what Comcast is saying is so nuanced that most people won't catch it. Comcast is basically saying, listen, the other civil rights acts, we do them this way, so we should do this one this way too. This is a different civil rights act. It's a different statute with a different congressional intent. And so just because the courts have interpreted one civil rights act one way does not mean that the other civil rights act has to be interpreted the exact same way. And that's really what this is about. Comcast is, I think it's a mind fuck. It's a mind fuck. Because, most people who are familiar with Civil Rights Act of 64, and you understand that Title VII claims don't allow for mixed motivation discrimination cases, right? Mixed motivation meaning that it's just a factor, right? And so Comcast is like, we should do the same thing. 81 is civil rights, right? Which it's not that simple. It's not that simple, okay? Because the law turns on factual differences as well as legal differences, okay? And so I think it is, it's important that the distinctions between the oldest Civil Rights Act in our country, which is 1866, and other acts that came after it, right? The congressional intent completely different. And the ways in which these acts are applied also should be completely different. That's how I see that. Pull out the industry. All right, I'm gonna check the comments, guys, and I'll try to respond to as many as I can. I don't know if I can respond to chat comments, so if you have a comment that you'd like me to respond to, I'm gonna ask you when the video goes up to put it in the comment section so that I can respond to that. The fact that this lawsuit got the attention of this administration should say a lot. I agree. Not only just got the attention, but they filed amicus. And, oh, wait, the other thing is I believe I think they had maybe 15 minutes for oral arguments each side. I believe the petitioner, who was Comcast, because they petitioned for the to be heard in the Supreme Court, so they were the petitioners. I believe they gave some of their time to the lawyers for the DOJ. Yeah, so not only did they show up as amicus on paper, they showed up to argue. And if we talk about the makeup of the court, I almost went off without talking about that. If we talk about the makeup of the Supreme Court right now, yeah, I think it's 5-4 leaning conservative right now. It's 5-4 leaning conservative. And so if they vote in that manner, then it's very likely that Byron Allen will lose this case. But, you never know, because there have been some swing voters. There have been some swing voters. Chief Justice John Roberts, I think he hates Donald fucking Trump. And so anytime he has an opportunity to stick it to him, I think he does. So, I'm hoping he'll be on the right side of history. But we've got RBG, Ruth Bader Ginsburg. Although she's been sick, she's still a Supreme Court justice. And she ain't going to retire. She is going to die in office because she will not let him replace her at all. So we've got her, we've got Sotomayor, we've got some, but we definitely need some of the conservatives, or at least one of the conservatives on the bench to side with us on this to side. Well, yeah, I'd say us. That's fair. To side with us on this case, and we'll see. It'll be interesting. I'll be looking out for the decision, and I'm sure I'll go live when I get it, and then we'll talk about it, and we'll see where we go from there. Comcast asked the DOJ to step in on their behalf. It doesn't matter whether they asked or DOJ offered. They showed up. Listen, if you call me for certain types of things, I'm not fucking coming. I don't support that. I'm not coming to that. So if Comcast called up the DOJ and said, hey, listen, they're trying to expand 1981. They're trying to do something different. We need you guys to come in here and back us up. If the DOJ didn't agree, they wouldn't have showed up. They wouldn't have shown up in the way they did. Right? And so it doesn't matter who called who initiated the conversation. None of that matters. Right? They showed up and they showed out. As far as I'm concerned, they showed out. All right. Brett Kavanaugh, but listen, stranger things have happened. Stranger things have happened. And I'm not going to be surprised if we get one or two conservatives who say, listen, we're going to do this the way we've always been doing it. And this statute is different than other statutes. We've already said that. So we'll see. You're welcome. Good. Mr. or Mrs. Vosley, for checking out the SCOTUS website. It's important and it's interesting. Like I could be on that thing for hours. I'm a whole nerd though. That's what I really am. I go from brief to brief to brief, petitioner brief, respondent brief, amicus brief for petitioner, amicus brief for respondent, and really get engrossed in that. So I don't think Comcast has the legal authority either to support their argument. So we'll see. We'll see what happens. Okay, family. I love you. I really do. I hope this helped. I hope it explains some legal principles that you may or may not have been familiar with. If you have any questions, put them down in the comment box below, and I will respond to them. At some point, I'm going to edit this, and I'll put some links to some of the stuff that we talked about. I'll put some links down in the box. Okay, fam? Thank you. Welcome. You're welcome. It's my pleasure. It absolutely is. All right, y'all. Ikie speaks. I love you. I really do, man. I really do. Peace.